that start negotiation, it is subject to that the Kazakhstan and it will be realized in Kazakhstan. So the issues that for example, the US court and as a seat of arbitration in Dubai and so on, it doesn't work because there is no setting. You cannot find the regular circumstances. And that's why the jury starts when you draft the contract and you should estimate in case of a dispute and which the method and which place and which type of method they should be much more visible, mediation or the arbitration. That's quite important. Definitely, and if I have a dispute in Kazakhstan, then I should choose a day. More than that, you can find that the right expert, you can find that the right knowledgeable counsel in that. The corporate perspective, and it is subject to the Turkish territory. And if contract executed in Turkey, and you can go to the International Arbitration Centre because that award the direct and process in Turkey, and you should insist on using that method instead of going through the litigation. Because if you go to the court and apply and for a case, and you can get the first case made at least and be 9 months later. Means if you apply to the arbitration, then you can get the award within a year and maximum 1.5 years. Means a very efficient and also cost benefit benefit you can see in that process. And that's why, and you should define when you start a contract and each method you should. That's my point. Not only the breaking up in general or
Thank you. Let me shift the discussion a little bit. I'm sure over the years you've used many counsels. Some you like, some you didn't like. So perhaps you could share your thoughts on the do's and don'ts for outside counsel engage. How do you choose your counsel? How do you assess your counsel? What mistakes you see without any names? When you're surprised pleasantly or not in that John, this time let's do it geographically. You get the point.
Most important thing is mutual investors. Because if in-house team and the external team doesn't work together as a team, you cannot be successful just like that's why. First, the in-house team should know what's going on the business and what's the critical point of the contract. And also, you should transfer that knowledge, the appropriation that they sort of pass without an hesitation. They should discuss and they should assess everything, or writing or writing or something. Then, you can be a successful process. That's my understanding. Time to time, we see that the in-house teams hand over the case to the external counsel, and also not taking any risk perspective, never say, never comment on that issue. They say, oh, and we hand it over and we pay. A certain amount of that money to the external counsel, this is their problem. If they lose that case, this will be their fault. It's not our fault. But if, from my perspective, it's not the case. Because it's in-house counsel and you should be a business partner. It means that you should know that business and you should manage that case. You get the external. It's without collaboration and you cannot get any success in any dispute type. Even in litigation or in the area. But in arbitration, if you cannot give them the right sense and the right information to the external, and you cannot manage them.
To follow up on John Day's comment, if your cell phone is silent, make sure it's a vibration, otherwise even this calls for the clients during the session. Najan, would you comment?
Yeah, I agree with my colleague as well as yeah, you need to have counsel that actually understand people, understand how to operate, understand your philosophy and policies as well. From our case, we have several laws, we work with several laws, and now we are kind of creating a panel of laws working. But from for e-counselors, actually, I think the most important thing is not only hiring counsels, external counsels, but also important to kind of cooperate between the business, units of your company and this external counsel successfully to explain what actually needs their advisors. So sometimes we see when whether business or whether in-house doesn't really understand what's going on in the case. And I think the in-house lawyers have to have ability to manage this jointly with jointly. So shouldn't be the job of the external counsel or in-house lawyers taking their job. So if there is no application, there is joint work, and in-house lawyers have to understand that the main goal of the in-house lawyers not only is solve the matter of the case, but also successfully operate, successfully work, make business beneficially. So the goal is different. So there is not only there shouldn't be any kind of competition between councils. So it's our approach.
But if you freelancers stick,
I would like to side with my reachability. I agree with the other thing availability debating with his wife. I don't know if you what's going on, wisdom, and I want to deal with one part and move forward. You have to trust the relationship first. The other thing that you mentioned, was not to mention fees. I think the good old days where you charge 1,200 for one time, and you charge it by the hour. In some areas, well, you need to think what the possible comes out of here, where you would share the risk, you would share the financial. I've seen many good arrangements like that, where it's got to be a budget for all the work in exchange for. But this is the judging by the hour is over.
you've made a number of lawyers that sad. cases where you share the vote?
Maybe not an arbitration. I can also say that we have a fairly strong team in terms of disputes in our in-house team. But again, when we need external support, we normally either use, whenever we know that some firm, we work with that firm and we trust the team, we choose them just to handle that dispute. Because we more or less understand the policy there. And also, it's much easier because they know us, they know what to ask, it's much more convenient. On the other side, if there is some dispute in a weird jurisdiction where we have a litigation or arbitrator or whatever is happening there, we just check the market. We check this our colleagues even from law firms because sometimes when people interact, they have some less understanding of the team. Then we try to get things with the team, check their experience, and then we see the price increase. Because I mean, the range could be absolutely different, but the price is very important for us, and we don't. We take that into consideration in addition to the process.
Thank you. Jamal has kindly agreed to review the actual ways he chooses outside counsel. I invite the other speakers to do the same to the extent they agree.
Yes, one of the important points is how you can choose the right external counsel in case of the dispute. Of course, and we are under pressure of the judges and fees, but I believe that we have some and also an arbitrator. And a good lawyer deserves that a good pay. No doubt about it. Because if you, they cuts that the budget, and if you say, you should do it with that and so on, and how you can they expect very quality and 100% perfect service. Because I've been all the time, most important thing for the lawyer, and we should recognize their experience there. In many of the companies have prepared the beauty contest. It's the internal jargon, you may have heard of. And in that the beauty contest, and they choose the first according to their experience level and so on, and prepare a panel. And to enter into the panel, and also now feel that the panel will get issued for many of the companies. The most important fighting point in the company is the procurement, because they say also the legal services should be procured by them, and they do not choose that the legal firm in case of a dispute according to their the fee offered. But this is not the case for us, and of course, and we find some tricky ways in accordance with the compliance rules, 100% sure. And at the end, we choose the fee whatever we like, because we know, and in case of we have a dispute, in which company can manage in a proper way, because it depends on the track record of the previous case, the results, and also their experience level. Sometimes as a personal contact, definitely is playing a crucial role for choosing the right the legal firm perspective. And we are not eager to change that we and we are very important human. But again, I would like to say the most important thing is that the reach to the team to the external law firm. Because and when they call from the external firm, and 24 hours and 7 days they can reach. And if I can reach at the same day as the restaurant, that's the criteria that I use.
Your comment about fees deserves a round of applause from external lawyers. Anyone else on how you actually choose the external counsel to the extent you've been willing to share?
Yeah, choosing is important. So, yeah. Luckily, the central bank is not bounded by the state procurement law. We have own regulations on that matter. And of course, we have already discussed it. We included the panel to kind of compare the prices as well, because we can choose. We have different kind of law firms, big ones and small ones, to compare the prices, compare whether they can operate on that matter, whether it can be that we can. We do choose before that the number of panel lawyers or law firms. And then when the case arises, we actively work with them, whether they can work and how much they can do. And of course, hourly rates can be done for longer cases, while for small cases, we usually do some estimated number of amount of money. So, it's very difficult. I understand to choose between law firms, go through the procurement procedures, because not only the prices are important, but also how comfortably you can work with these lawyers, external lawyers as well.
Anyone else? Or feel free to decline. I understand this might be confidential.
No, I think I can just maybe say principles. One of the principles we try to follow is diversity. So we try help available engineers to have a long-term relationship with them, not necessarily giving them work in any particular moment, but a kind of framework that we can follow for any particular matter.
Maybe it's looking for to answer. Or,
sorry, what is the particular question?
how do you actually choose? How do you actually choose your external counsel?
No, but I've answered that. Yeah, that's the answer. So we basically see the technical, and then we also take into account the fees. Sure. Of course, we will not take the cheapest one with poor technical expertise, but we just trying to find some balance. In terms of availability, or say reachability, whatever, it's important too. But I think with a good planning, it's not a big deal. If it is an emergency, of course. Emergency arises when you need to respond. That's really that's a point. But when you file, then you have some leverage in time to make it more. You can think more. You see that time.
Thank you. We're 6 minutes away from the end, so I invite questions from the audience. Please feel free to raise your hands and ask questions.
So for this insightful discussion. So, Mikit, you mentioned that when it comes to choice between AIFC and domestic litigation and arbitration, one of the things that we consider is that domestic litigation is faster, but the quality of it could be better. So, and one of those things about the quality of domestic litigation is that application of law is not predictable, as Mr. Kramer shared as an example with penalties. So, but also, on the other hand, have to consider that AIFC litigation resolved around 95% of its cases based on Canada substantive law, not AIFC law. So could you please say that, do you think that AIFC court right now is predictable when it comes to application of Kazakh law?
So I can explain this way. So for me, as a former AIFC employee, so I was actually one of promoting a AIFC court and arbitration center in the government. So because of our joint work with Christopher, we have a lot of contracts in AIFC law. But most of these contracts usually are investment contracts and complex contracts. And when you compare as an in-house lawyer, when someone is proposing AIFC court or arbitration center, usually they propose in complex contracts or investment contracts when the case possibly can go to the arbitration. But in our cases, we usually have Kazakh law and Kazakh courts. So usually in more predictable, more clear cases, procurement cases, procurement contracts. So when you can, in fast manner, can do and can solve the case, and while it's complicated or some probability of disputes are higher than usually the opposing parties. The funny thing is, opposing party is proposing to me to include AIC Court and Arbitration Center in nowadays. So it's just a little bit funny for me for promoting AIC before that someone has already explained me how AIC Court is good. So yeah, we have cases, but usually it's the most complicated contracts.
Any other questions?
I will just ask a question that continues the previous discussion. We discussed a lot about how to choose counsel. And then my question is kind of similar. When is it time to change counsel? Even, for example, in case, as I'm sure it has already happened. Of course, no need to call names, just in general.
Anyone?
And take some counsel.
Yes.
If necessary, you can change, no problem. You can terminate the contract and you can assign anyone else. From in-house perspective, it's not easy. It's not an issue. But of course, if you have some penalty, I'm joking. It's not so easy to change that external counsel, especially in the middle of any dispute process, because then you share everything, and to create a new one with full knowledge, and also giving the right strategy again to anyone else, it's not so easy. And if you are not satisfied in the middle of that process, this is your fault, and you should find a way how you can manage this situation at the end of the process, and you cannot choose again for any other disputes. That's the result also to my way.
Anyone else?
So yeah, the changing external counsels extremely difficult, especially during the process, arbitration or litigation process. And of course, we have the similar questions from my management when I came to the National Bank. They wanted to change the external counsels. But the matter was not about the counsel itself, but the matter was in approaches and understanding what actually you can do as a in-house lawyer. So when of course you can change it, but the costs are higher, and if it's in litigation, in the middle of litigation, you can't be sure that it's a right way of doing business. If you decided to change it, you have to kind of have some time to do it. Doesn't matter during the process of litigation or in the other processes. So you have to kind of work together anyway with the counsel who is living and with the counsel who is coming. So it is possible to do, but it's complex and difficult, and you have to assess those people who do it.
It was an interesting question, by the way. I've been in a situation that I can share where I'm in the middle of arbitration. It was 15, 20 years ago. And suddenly my external counsel informs me that they are subject to merger, and therefore I'm no longer their client. So sometimes it is prudent to check before you start litigation arbitration where your firm is actually committed to be with you. And I agree with colleagues that in most of the cases, changing the external counsel in the middle of arbitration or litigation is a bad thing for the counsel. But they could be situations. Be careful when you choose external counsel before you start. Like another Russian saying, and he which is, I don't know the English translation of it. You don't change courses, you it's a good Russian saying. We prefer not, but can be subject to the other people thinking we should.
We're out of time, so I'll have to conclude. I think the session was both useful and joyful, with a light touch of humor, appropriate for the second day of the conference, the difficult morning. If you have any further questions or comments, let's take them.